Hello, students. Mr. Davila and I will be presenting your first required Supreme Court case. This serves two purposes. One is to teach you about this important case of Marbury versus Madison. And secondly, we're modeling for you how to do your presentation. We also are it's going to be a little tricky because we're trying to explain it as if you could be doing it remotely or if you were doing it in person. So keep that in mind. But anyway, here we are with Marbury versus Madison. So we're always going to start out with the background of the case so that students can get the context of what's going on. Normally, again, if we were in person, you would just provide this to students in the form of a handout. You would give them a handout with this already typed up, the explanation of the background. Since we're doing this digitally or remotely, we're going to go ahead and explain the background to you on the presentation. So, Marbury versus Madison. So to give you context, by this time, there were two political parties that had been created in our system, and they were the Federalist Party and the Democratic Republican Party. So the 1800 election pitted John Adams against Thomas Jefferson, and Jefferson won a decisive victory in 1800. Not only were the Democratic Republicans set to take over the White House, but they won a huge victory in Congress. They were set to take control of the House and Senate. And so, so obviously the Federalists were feeling a little desperate. John Adams and the Federalist Congress decided to hold what we call a lame duck session of Congress. This means after the election, but before the new president and Congress take office. And so they held this sort of special session and passed something called the Judiciary Act of 1801. In this law, they created a bunch of new federal judgeships. And their plan was then to stack the courts with as many Federalist judges as possible. So if they were going to lose control of the presidency and Congress, at least they could still have control of the judicial branch. Remember, these would be lifetime appointments, so they would hold control of the judicial branch probably for some years to come if they were successful. Because these appointments, though, were made at the last minute, they're often referred to as the midnight appointments because literally in Adams' last day as president, they were still trying to deliver these judicial commissions, like officially make these appointments. And so not all of the commissions were able to be distributed in time. The new Secretary of State, James Madison, and Thomas Jefferson come into the White House on their first day, and Madison finds these envelopes on his desk. What they were undelivered commissions. Some of the commissions weren't able to be delivered in time, so these judges did not officially get their appointments. And so Thomas Jefferson, of course, was very angry about this whole maneuver that had been done by the Federalists. He saw this as a really highly political power grab, and he thought that this, although it wasn't illegal, that this was really a questionable act that they had engaged in. And so so he ordered Madison not to deliver these commissions that had not been delivered in time by the previous administration. Well, a guy named William Marbury was one of the judges. He was a lower level justice of the peace who had been appointed, who did not receive his commission in time. So seeking a legal remedy, he took his case to the Supreme Court and was asking the court to order through what's called a writ of mandamus, which Mr. Davila will talk about more in a few minutes, to order Madison to deliver this commission, which he felt was rightfully his. And so again, I'm not going to get too much into those details, but one ironic thing about this whole situation was that the Secretary of State, who was originally supposed to deliver these commissions but wasn't able to do all of them, was John Marshall. But by this time, he had been appointed by Adams to be the Chief Justice of the Supreme Court. So the guy who was supposed to deliver the commissions originally is now sitting as the Chief Justice of the Supreme Court reviewing this case. If this happened today, of course, there'd be lots of pressure for Marshall to step down because of a clear conflict of interest. But anyway, that's sort of another issue. So that's where we are with the background.
Okay, so in addition to the background, which you would have already handed out in the form of a document, to your classmates, and you'll typically not only have a hard copy ready, but you'll also need to post it online so students can access it that way. You'll need to also address the applicable law. In other words, what statutes, what articles, what clauses in the Constitution are particularly relevant, or what state law is being debated. To make very clear to your audience, your fellow classmates, what law is at issue in this case. In this particular case, in Marbury versus Madison, the applicable law will be Article 3, Section 2, Clause 2 of the U.S. Constitution. If you should remember, Article 3, of course, discusses the judicial branch and talks about how it's structured, what rules apply to it in terms of its powers, and as well as the jurisdiction of the Supreme Court, which is particular relevance in this case. And jurisdiction means the area over which the court can exercise authority or control. And that's a very important term for you to know. You should look it up. You should definitely write it down, because we'll definitely discuss it again. Jurisdiction, again, the area over which the court can exercise authority and or make decisions upon. So in addition, we have the Judiciary Act of 1789. And this act was passed by the Federalists, and in this act, they had changed, among other things, they had changed the original jurisdiction of the Supreme Court to include issuing writs of mandamus, which we know in this case Marbury is seeking one of those. Now, let me clarify what original jurisdiction is, because you'll need to understand that in order to understand why we bring that up here. Original jurisdiction simply means that that particular case, or that kind of a case, may be brought before the Supreme Court immediately without having to go to any other court. And basically, you go directly to the Supreme Court with those types of cases. As you can imagine, those types of cases are rather rare, the category of cases where you can just skip all the other courts and just go directly to the Supreme Court. And you can see, if you look in Article 3, what the Constitution says those kinds of cases are. It says, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. And so you see here, though, with the Judiciary Act of 1789, it expands that to include cases that involve issuances of writs of mandamus. And understand, writ of mandamus means that the court is requiring an official to carry out a certain action that official has otherwise not carried out. And it's maybe a mnemonic device you could use. Just think of mandamus, mandatory, mandamus, mandatory, mandating, requiring, right? Making it mandatory that an official carry out a certain responsibility. And in this case, of course, Marbury is wanting Jefferson to issue this judgeship to him. So that's what he wants to be carried out.
Okay, so we're going to look at some constitutional questions. This case is sort of unique because the court had to really approach this in a very strategic way. So what we want you to think about is, what questions did the court have to consider? What were some options in terms of how they approached this dispute between the two parties? Remember, this case is highly political, and Jefferson and Madison are already angry about what was done to lead to these appointments that Marbury was seeking. But John Marshall is a strong supporter of the Federalist Party, but he has to consider what's going to happen, if he orders that Madison, in fact, deliver this commission, if he does issue the writ of mandamus that Marbury is seeking. Because think about what is likely to happen. Will Jefferson and Madison just agree to this? If the court, in fact, rules them to deliver this commission, will they just readily then say, oh, well, the court has ordered us to do this, we must do it? Or is it likely that Jefferson and Madison will tell Marshall, to go stick it in his ear, right? If he tells them to do this. And so if he makes an order and they refuse to do it, what's going to happen to the court and their power and prestige, right? So that's why we have this little graphic here. And so Marshall, this is John Marshall, actually he was a graduate of William and Mary, which I should mention.
The thought bubble. You were
and,
thinking of the word
yes,
thought bubble.
the thought bubble. And he's saying, what should I do? Do I need to consider the political ramifications of any ruling that we might make? He doesn't want to appear weak. So he has to sort of figure out a good way to approach this case. All right, so let's look at the questions he has to consider. So first, does Marbury have a right to his commission under the law? So does he have the right to be appointed as a judge? The second question the court has to answer constitutionally is, if he does have the right to this commission, does the Supreme Court in fact have the authority to order that this commission be delivered? So in other words, do they have this power to issue a writ of mandamus to order Madison to deliver this commission?
Under their original jurisdiction authority, but anyway.
Right, so this is where, again, we're kind of telling you also not just about this case, but what you guys will need to do when you do your presentations, whether they be online or in person. Now, if it's in person, if we're in class, here's where you would want to pause and get the students to give you some feedback. So before just telling them what the court ruled, you want to first just pose the question or questions and have the students give you some feedback. So you'll call on some students to say, well, what do you think happened? What do you think the court ended up doing? Okay, so obviously if we're doing this online, you can't actually give us your feedback right now, but we do want you to pause and think about it. So what do you think Madison did in this, or sorry, what do you think Marshall and the Supreme Court did in this case with regard to Madison, and whether he should have to deliver this commission, and whether Marbury deserved that commission in the first place? So think about maybe how Marshall strategically approached this case.
All right, so in a unanimous ruling, the court decided the following, all right? And remember, these two questions can be answered differently, and we'll still have a consistent ruling. So let's see what I mean here in just a moment. So on this first question, does Marbury have a right to his commission under the law? The court's going to say yes. Actually, Marbury was entitled to his commission. The paperwork was properly filled out. The people who needed to fill it out filled it out. The only act that remained was the actual, delivery. Yes, and the president and Congress, right, authorized this. So all of those steps were properly followed and carried out. So as far as the court was concerned, Marbury was entitled to this commission. However, we're going to see that things can become rather complicated in the legal arena. So let's look at the second question. On the second question, does the Supreme Court have the authority to order the delivery of the commission through a writ of mandamus? Remember, the issue here is, right, that the court is making this determination in part because it was brought immediately to it as a result of the Judiciary Act of 1789, right? Marbury is saying, hey, there's this Judiciary Act that expanded the Supreme Court's original jurisdiction to include these kinds of writs. So that's why I'm coming to you, and here I am. And the Supreme Court is asking whether or not it has the authority under its original jurisdiction to issue this writ of mandamus. And on this question, Marbury is going to get a very unfavorable outcome. The court decided that actually it did not have the authority under its original jurisdiction to issue a writ of mandamus. And so ultimately, Marbury is going to lose on a technicality. Even though he was entitled to the commission and he rightfully looked and understood the Judiciary Act of 1789 in terms of what it meant, in other words, in terms of him bringing his case to the Supreme Court under original jurisdiction, he's going to lose on this technicality because the court's going to argue that when Congress expanded the original jurisdiction of the Supreme Court beyond what was in the Constitution, that was not allowed. That was an impermissible move, because the only way to change the Constitution is through the amendment process. And so you can't just add, if you will, things to the Constitution without going through the amendment process. And so we'll get into that here in a moment in terms of the reasoning, but I want us to be clear about the ultimate decisions issued by the court. Okay, so what's the reasoning of the court then? How does it arrive at this conclusion? And it's going to be very important in your presentation to spend some time here, okay? So you certainly want to make sure that you're clear and concise about what your constitutional question is. You certainly want to be clear about what the court's ultimate decision is on each of the questions if there are multiple questions to answer. Sometimes there's just a single question. Other times there could be, different questions. And here's another caveat, and Mr. Phillips, you may want to chime in here. Sometimes when you're doing your research on these court cases, different websites and reliable ones have different ways of articulating what was the question before the court to answer, okay? So sometimes there may be differences or variations on how to phrase the question that the court was responding to, but you should generally try to look at the language of the decision itself to determine whether or not they've accurately understood the question and how they've written their constitutional question. So I want to caution you against just copy and pasting what some website says the constitutional question is. Generally speaking, they're not too off the mark, but you may see some variation, and it's worth your time to sort of figure out for yourself, when you look at the actual language of the court case, or at least at some sort of summary of the court case, look at it, look through it, ponder it for a moment, because you may have a better sense for what that question really should be. But I say that just to encourage you again, do some of your own reading of the actual court case decision to come to a conclusion. You may not have to read all of it, but you should probably read some original portions of it if you can find them. You can find them. It's just a matter of looking. But I would be very hesitant to just rely on someone else's summary and someone else's opinion about what the question was that was before the court. Now, with respect to the reasoning here, Article 3 of the Constitution clearly defines the scope of the court's original jurisdiction, right? And to be specific, the Constitution defines the original jurisdiction of the court to include all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be a party. Now, you don't have to concern yourself too much about that language now, because we will certainly talk about that later when we talk about the judicial branch. But you should understand that that language, nowhere in there does it say writs of mandamus, right? That's what the court's saying. Nowhere in the nowhere in the Constitution does it say that original jurisdiction cases includes writs of mandamus. And the fact that this act of Congress tries to include it as one of the possible cases was not permissible, that they did not follow the right protocol in order to do that. If they wanted to do something like that, they could have proposed an amendment and then see if the states would ratify that by a 3/4 majority. But this route of just by an act of legislation, no go, right? Not permissible. So ultimately the rationale here, how the court sort of expounds upon this, they say, look, the Constitution is the highest law of the country. It is the supreme law of the country, right? The supremacy clause of Article 6 makes this clear. If you look at Article 6 of the Constitution, it makes quite clear that the Constitution is the supreme law of the land. Therefore, they argue, any conflicting law is invalid. And so because the Judiciary Act of 1789 is expounding upon something that the original Constitution did not have, this is a situation where the Constitution's language what we say in the legal field, controls, okay? The constitutional language is what will reign supreme, if you will. So we'll just use the language that we have before us. Let's move it along to the next slide, because I want to give you some quotes. I want to give you some quotes. I realize sometimes when we transition, you may not hear my voice. So let's look at the actual language from the court decision, right? And this is yet another piece that we really want you to spend time on. We want you to spend time on, of course, all the parts, of course, but some of the parts require a little more thought. So making sure you understand the constitutional question is really critical. Making sure you understand what the actual decision of the court is critical, but that one's actually more clear usually than in other places or than in other areas. But the reasoning, it really requires some time and reflection. So in addition to your summary, as you can see in the prior slides, we put it in our own language, what we thought the reasoning and rationale was of the court. So you have to do that. You have to reflect to us that you've actually thought about it and you understand what the court's reasoning is. In addition, though, to help support you in that effort, and also to make clear to us, the audience, that you know what you're talking about, or that we should believe that you actually have an accurate understanding. You want to provide evidentiary support. So provide textual support. In other words, provide language directly from the decision itself to demonstrate how it is you've arrived at this summary of the court's reasoning. So here you can see, for example, certainly all those who have framed, where Marshall mentions, certainly all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation, and consequently, the theory of every such government must be that an act of the legislature repugnant to the Constitution is void. Essentially, what he's saying here is that the Constitution is the supreme law of the land. Anything that conflicts that is invalid. Next quote. And this one is going to be really important, and I'm going to sort of just keep my commentary to what's on here on our screen, because Mr. Phillips is going to explain the significance of this concept. But the court goes on to say that it is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to particular cases must, of necessity, expound and interpret that rule. If two laws conflict with each other, the courts must decide on on the operation of each. Okay, let me sort of simplify this for you. Right, what's going on in this court case is a lot more than just whether or not Marbury gets his judgeship. There's a much bigger story. Okay, and Mr. Phillips had already talked about that a little bit with that thought bubble that we saw from Marshall earlier on. What are the political ramifications of this case? Were huge because, as Mr. Phillips already articulated, the court was really between a rock and a hard place. It had to, on the one hand, make sure that it didn't issue a decision in a way that the executive and legislative branches would completely ignore it, and then make clear how weak their branch was, since this was the only branch the Federalists had control over. But on the other hand, it didn't want to seem so weak and willing to capitulate to the executive branch, which had flaunted, right, or decided to just ignore this writ that was this judgeship that was commissioned before them and not carried out. So they didn't want to look weak on either account. And so they were really having to walk this tightrope in terms of how is it that they could accomplish their goal without being completely ignored. And so in this case, we can see the court says, hey, one of the other questions that may not have been spoken here is, can the Supreme Court weigh in on this issue at all? In other words, can it sort of resolve these kind of conflicts that are political in nature to some extent? And so in here, the court makes clear that, it is emphatically the province. It's obvious, if you will, that the judicial branch has the power to say what the law is. They're there, they're tasked with interpreting the law. So if you're tasking them with interpreting the law, then they're also there in the capacity to say what the law is, right? And its applicability. So they're there to determine if laws conflict and ultimately to determine if acts of Congress are in fact in conflict with the Constitution. So I'm going to leave it there and let Mr. Phillips take it from there.
Okay, so Marshall brilliantly, as you might expect from a William & Mary graduate, walks a political tightrope. So again, as Mr. Davila said, he avoided the embarrassment of having to make a ruling and say, hey, you guys need to deliver this commission, which he probably would have liked to have done. But then he knew the executive branch would almost certainly say, heck no, we're not doing that. So basically, even though they sort of lose the small battle here, they win the war, right? So Marbury doesn't get his commission. They have to kind of, recognize that's not going to happen. But they win the war by saying, you know what? We have the final say on the Constitution. So and it's also important to note that up to this point, the Supreme Court was definitely like the redheaded stepchild of the three branches. They had not sort of established themselves as a co-equal branch. But this case is what often is pointed to as doing just that. So he expands the power of the court by saying, hey, we are the ones who judge the laws. And even though that was understood to probably be true by most of the founders and the framers of the Constitution, it was not stated in the Constitution. It's never clearly stated that the judges have this power to judge the laws. I think it was just mainly assumed to be what we would call probably an inherent power. Of course, obviously the courts judge the laws. What else would a judge do, right? So yes, they settled disputes, but obviously a big part of their power and their function is to judge the laws. And if the Constitution is the highest law, as Mr. Davila said, you can't have other laws conflicting with it. So this is where they confer upon themselves. And so you'll see this case a lot of times. I get irritated when they say this case created judicial review or established judicial review, as if it didn't exist before and they just created it out of nowhere. No, it was already understood by I think, I said again, most of the founders, that this was a power the courts had. So it's really that they're conferring this power upon themselves. They're confirming that yes, in fact, we have this power and we're about to use it. Okay, and so this is the first case where the court actually uses the power of judicial review. But yes, they're also sort of claiming this power and making it clear. If there was any doubt, yes, we have this power. And this has become the most important power, that the judges have, and the most important power in the system of checks and balances, where the courts can keep the other two branches in check by declaring their laws or their actions to be unconstitutional, right? And that is what judicial review is, right? The power of the courts to declare laws of Congress or actions of the president or of the state governments to be unconstitutional or to be void if they violate the Constitution. And so here's the definition. So judicial review is the power of the courts to determine whether or not acts or actions of the government are constitutional. You must know this. You must understand this. It's very important. And this gets to the heart of why this case is so important, right? Again, not because Marbury, whether he won or lost, that was sad for him, but that's not really the importance, right? This is the key. And so this is where you guys will explain. So not only is, as Mr. Davila said, the reasoning of the court very important to understand when you guys eventually do your SCOTUS comparison FRQ on the AP exam, where you have to compare one of the cases that we've taught you or that you've taught each other with a case that you probably have never heard of, that they give you information about. So you have to not only understand the reasoning of the ruling, but the significance of the ruling. So why is this ultimately important? Why do we care? Why did the College Board pick this as one of the 15 required Supreme Court cases out of thousands of cases they could have chosen from, right? So again, the reason this case particularly is so important is because Marshall makes it clear that judicial review is a power of the court. It's an inherent power of the court, that of course they're the ones who decide what the law means, and of course they're the ultimate ones who get to decide what the Constitution says. They're the final arbiters of all law as it relates to the United States Constitution. Okay, so that's at the heart of this case.
Okay, so and before I get into the similar cases, one other thing I wanted to add is that Marbury is an interesting case for a variety of reasons. It's a seminal case, it's a landmark case, it's a hugely consequential case for sure, but it also demonstrates to you that sometimes the significance of the case has maybe not very much to do with the actual actors and what happens to them. In other words, we don't really care very much today what happened to Marbury, but we care tremendously about the fact that the implications of this case had established judicial review and made clear that the judicial branch was a co-equal branch. Marbury did not have that as his intention when he was bringing this case before the Supreme Court. So I need you to understand that the implications of a ruling of a court case can have ramifications well beyond the parties who originally were involved. So this is something to keep in mind, that sometimes you can't fully anticipate what the full ramifications will be of your court case until it happens and you see what the court says. And frankly, until we see what courts in the future say about your case, because we live in what's called a, oh my God, now it's going to escape me. Tell me real quick.
What? I don't know what you're trying to think of.
Okay, came back to me, sorry. Common law country, which means that we will look to prior court decisions to help guide future decisions in court cases. So what courts decide in the past or in any case will have influence and in some cases be controlling for what happens in future cases. So these are very, very important to understand and fully appreciate. And here's a perfect example of what I mean. In these cases, Youngstown Sheet and Tube Company versus Sawyer, you can see a 6-3 ruling where the Supreme Court denies the president at that time, Harry Truman, the attempt to use emergency powers. And if you're wondering why he thought he needed to use emergency powers, we were coming off the heels of World War II. World War II had pretty much ended by this time, but we were also in the midst of the Korean War. And the Cold War had started. I know I'm throwing a lot of wars at you, but the point of the matter is that is why Truman is saying he has the authority to issue these emergency powers, especially over what is a critical industry, in this case, the steel mills. And the court struck down this executive action as being unconstitutional, that the president was overreaching here in their authority. And so again, the idea here that the judicial branch has even the authority to rule an act of the president, sorry, an action of the president unconstitutional is, of course, a byproduct of, if you will, or it derives from the decision in Marbury versus Madison, where the court was given that authority. Numerous other Supreme Court rulings also have been made on issues of federal and state laws and other governmental actions where the Supreme Court has declared them unconstitutional or has expanded their interpretation. So there is a plethora of cases you could look at for similar cases. But I do want to stress here, you are required to present similar cases that either preceded your court case. In other words, there may be instances where your court case was one in a long line of decisions that ultimately things changed. So you may, for example, with Brown v. Board, you're going to absolutely have to mention Plessy versus Ferguson. They do, clearly, but there may be other cases leading up to Brown v. Board that were really important for understanding how Brown v. Board even got to be, you know. And then you also have the option of just looking at cases that have built off of it in the future or after your case was decided. Or how your court's decision was limited. For example, in Roe v. Wade, even though the right to an abortion was maybe established there in the 1970s, court cases that followed Roe v. Wade still allowed for abortion, but had allowed for many more limitations to be placed on abortion. So there are a lot of different ways you can go with this, but you absolutely have to show your classmates what court cases, either that came before or after, were affected by your court case that you're presenting on.
And the final thing we're going to ask you guys to do when you're doing your presentation is come up with, in this case, we said how to remember, a nice play on words there, but to remember the case. You can use memes, which I think tend to maybe be overused sometimes because you guys tend to like those a lot. But, even better, we couldn't really think of a good one for this, but even better is if you can come up with just a helpful way to remember the case. So it could be through a meme, but it could also be like a like a mnemonic device or just a little phrase that you come up with, right? That helps students remember the case, right? I don't, can you think of any good ones that students can, like, Roe v. Wade, I don't know, like that she rode her way to more rights, or I don't know, you just think of a way, that's not a great example, but just think of something, that would play on, that would help students remember the main facts of the case or what was associated with it.
I mean, and just be clever about it. You guys are typically a lot better about that than we are. I mean, obviously we can come up with ones that make sense for us, but the idea is to help each other out in terms of when the AP exam comes along, so that you have a readily accessible way to remember information in vast quantities. I mean, you're going to have a lot of things that you're going to need to remember, and this is just a clever way to help trigger and activate and access that information real quick.
Okay, so in this case, of course, the memes we found are emphasizing the importance of judicial review. Marshall also says, let's put the Supreme in Supreme Court, so that would help you remember that this establishes the court as a co-equal branch and as the ones who get the final say on the Constitution, the supreme law of the land, etc. And also just, of course, repeating, he's saying, yo, dog, I heard you like judicial review. So I use judicial review to give myself the power of judicial review so that I could judicially review judicial review. I'm not even sure I understand that, but you get the point of judicial review. Like they gave themselves the power to strike down a law, and said, in this case, the law that was giving us this power was unconstitutional. So that's pretty much, again, we're trying to present, we're doing more than what you guys are going to do, because we were trying to present the case, but also show you how to present a case to the rest of your class. So obviously, your presentations will probably be shorter than what we just did, but hopefully that helped you. Let us know if you guys have questions, and we will see you guys later. Thanks.
See you guys later.